Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
Alright, today I'm at Brisbane Magistrates Court. Client was charged with high range drink driving, reading at .217, so more than 4 times the legal limit. Further to that, she was in a collision. So basically, she's drifted and hit a guardrail and destroyed her car and part of the barrier. So yeah, high range drink driving, reading at .217, and single vehicle accident. So it was quite a serious matter. High range drink driving, a couple of things. You cannot get a work license. So when your reading hits .150, work license is just not an option. If you're .149 and below and you meet certain other criteria, then yes, you are eligible to apply for a DUI drink driving work license. But high range, .15 and above, it's just not an option. So as a starting point, my client was not eligible to apply for a DUI drink driving work license, and my job was therefore one of getting the disqualification down as low as possible, as opposed to maintaining your ability to drive on the road during a disqualification, which can be done when you are eligible and successful in applying for a DUI drink driving work licence. Penalties, worst case is a lifetime loss of licence. Magistrates have got a discretion to do that. Worst case is lifetime. Mandatory minimum, absolute best case when you hit .15 is 6 months. But when you're well into the twos, which my client was with .217, if I go in a court asking for 6 months for a reading of that nature, A, I'll get screamed out of the courtroom, and B, the pendulum will overcorrect and the client will be demolished, metaphorically speaking, obviously. So realistically, when we've got clients approaching us with readings starting with 2 and above, our goal is to get it under 12 months. So if you go there by yourself with a lawyer that doesn't know what they're doing or doesn't specialise in traffic, so that's the thing with traffic law, it seems quite narrow, like, oh yeah, drink driving, drug driving, demerit point suspensions, how hard can it be? But it's like a chasm on the Antarctic ice. It's just a little crack, but it just goes down, and it trips a lot of lawyers up who do the old, I'll have a crack kind of thing, because it's a very deep and complicated set of laws. I don't know why they're deep and complicated, but they just are, and it trips a lot of non-lawyers up and trips a lot of lawyers up. But in any event, I'm sort of going off point. But what I'm getting at is, if you go there by yourself with someone that doesn't specialise in traffic law and someone who speaks like Michael Jackson at court, you won't get much change out of 18 months, sometimes 2 years. As I said, we tell clients with a 2 in front of their reading that we'll go our hardest to get it down as low as possible. If we can get it under 12 months, that's a good outcome. If we can get it lower than that, it's a bonus. So prior to today, we sort of made it clear to the client that the goal is get it under 12. They were happy with that, and obviously 12 is a lot better than what you otherwise might get if you didn't pull out all stops to try and suffocate the outcome. Just smother it with a fire blanket, which is basically what we do. Identify the spot fires, smother them, choke them with oxygen, and all that's left is a notional penalty, and people are happy. In any event, prior to today, we got instructions from the client, got her to complete the reformatory course we get all of our clients to do, got her to get references based on the templates we give all of our clients to give to their referees. Drafted my submissions prior to today, met the client at court, grabbed the comments room, ran through what I was going to say, what we could anticipate the prosecutor to say, and the likely responses from the magistrate. Given to my client's pretty much complete lack of history, there was certainly no drink or drug driving in the history, and there was really only one ticket, a single demerit point infringement notice, and that was it. She'd done the course, so I had a lot to work with as far as positives go. So I sort of got a bit cheeky and went low, fully expecting the magistrate to, you know, look at me over their glasses and, you know, do the whole, what do you want to be, what do you plan at, Wiseman? But I thought, no, look, you know, it's a Friday, the sun's out, I'm feeling good, client's, you know, a lovely lady, I'll just go hard and see what happens. So as a starting point, I just went hard at 8 to 10. I was never going to ask for 6 because, as I said, you'd be screwing into the courtroom and you'd end up with 18 months. But 8 to 10, you know, keeping in mind, we're talking .217. Ordinarily, we consider an outcome of 12 months and below to be a good outcome. But on a whim, I just thought, stuff it, I'll go hard for 8 to 10. I laboured the fact that she'd done the course, and laboured the fact that it's likely that she's the only one in the courtroom who's actually done it. Laboured the lack of history, laboured the words of her referees, etc. And again, you know, even when I made that submission, the magistrate did raise their eyes and goes, 8 to 10, you reckon, Mr. Wiseman? And I didn't just say, yes, Your Honour, I spoke further, but, you know, further sort of trying to fortify the position. Yes, even I'll admit that I was going in low, and, you know, in any event, that's what I'm here for. I'm prattling on now, but the long and short of it is I was successful in getting a 10-month disqualification from my client. So 10 months, keeping in mind that's for a reading of .217 with collision. 10-month disqualification, that's very good in my mind. Client's very happy. So she's off the road for 10 months. Modest fine. In 10 months, she'll take the steps she needs to get a licence back, and it'll be behind her. So she's very happy. I'm Andrew Wiseman at Brisbane Magistrates Court. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment, or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.
Don't